Welcome to Talk Trials. Today we're opening the file on a legal concept that feels, well, a bit like a paradox.
It really does.
I mean, we usually think of courts as places that are trying to grab power, right?
Yeah.
But today we're looking at the exact opposite. We're looking at what happens when a federal court has the power, has the jurisdiction, the parties are right there, and then it just decides to walk away.
It's a fascinating corner of the law. It sounds so dry on paper, abstention, but it's really where the tectonic plates of the American legal system grind against each other. It's all about that power struggle between the federal government and the states.
Exactly. We're talking about the abstention doctrines. And before we get into the specific flavors of this, we have to set a baseline. Because normally a federal judge can't just say no.
Right. You have to go all the way back to 1821 to a landmark case, Cohens v. Virginia. Chief Justice John Marshall, the titan of early American law, he laid down a rule that's echoed for 2 centuries. He wrote that federal courts have a virtually unflagging obligation to exercise the jurisdiction given to them.
Virtually unflagging obligation.
Yeah.
I love that phrase. It sounds so intense.
It is. It basically means if Congress gives the court a job to do, the judge has to show up for work. They can't just decline to hear a case because it's difficult or, controversial. As Marshall said, we have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given.
So that's the rule. If the sign on the door says open for business, they have to be open. But, and here's the twist, over the last 100 years or so, the Supreme Court has carved out exceptions. They realize that sometimes that unflagging obligation crashes headfirst into another massive principle, federalism.
Precisely. Sometimes a federal court barging in like a bull in a china shop can cause more harm than good. It might trample on state sovereignty or disrupt these complex local policies or just waste a tremendous amount of money.
So judges invented abstention.
Yep.
It's a judge-made collection of rules that lets a federal court say, yes, I can hear this case, but for the sake of the whole system, I won't.
It's basically a diplomatic retreat. So today, we're going to unpack the 3 main flavors of this doctrine. They're all named after the Supreme Court cases that created them, which helps keep them straight.
Right. We've got Pullman, Burford, and Colorado River. 3 different scenarios, 3 different reasons to hit the brakes.
Let's start with the first one, Pullman abstention. This is often called the wait-and-see doctrine. And the story behind this case, Railroad Commission of Texas v. Pullman Co., it's a fascinating window into 1941 America. It's not just a dry procedure case. It's a civil rights story.
It really is. The facts are critical here. You had the Texas Railroad Commission, which, regulated the trains. They issued a rule saying that sleeping cars, the cabins on overnight trains, had to be in the charge of a conductor, not a porter.
And we need to decode the language of 1940s Texas here, right? Conductor was a job almost exclusively held by white men.
Yes, and porter was a job held almost exclusively by black men. So this seemingly technical rule was really a way to strip African-American porters of their jobs.
Exactly. It was a racially discriminatory labor rule disguised as a safety regulation.
So the Pullman Company and the porters sued. They go to federal court. And they had this 2-pronged attack, which is the key setup for the whole doctrine.
Right. Attack number 1 was the U.S. Constitution. They argued this rule violated the 14th Amendment's Equal Protection Clause, a heavy, classic federal question.
But they also had attack number 2.
A state law argument. They argued that under Texas law, the Railroad Commission didn't even have the authority to make this kind of rule in the first place, that they were acting ultra vires going beyond their power.
So the federal judge is sitting there with a choice. He can strike this down as unconstitutional discrimination, a massive ruling. Or he can look at the Texas statute and say, actually, the commission just can't do this under state law.
And here's the dilemma. The Texas law was unclear. It was ambiguous. Nobody really knew for sure if the commission had this power because the Texas courts hadn't ruled on it yet.
So if the federal judge guesses wrong, he's forced to decide this huge constitutional issue unnecessarily.
Precisely. And the Supreme Court, led by Justice Frankfurter, looked at this and said, basically, we should not be deciding massive federal constitutional questions based on a tentative prediction of what a state law means. If the state court just says the commission lacked authority, the federal case is over. The constitutional friction is avoided entirely.
So the rule of Pullman is, if there's an unsettled question of state law that might make the federal constitutional ruling unnecessary, the federal court should hit pause.
Pause is the key word. It's not usually a dismissal. It's a stay. The federal judge holds onto the case, but sends the parties to state court to get that one specific state law question answered.
It's like saying, go ask your mom what she meant by that rule, and when she explains it, come back and tell me, and then I'll decide if you're grounded.
That's a pretty good analogy. The goal is to avoid premature constitutional adjudication and, to show respect. Federal courts shouldn't strike down state laws based on a misunderstanding of what they even mean.
But let's be real for a second. This sounds great in theory. But for the litigant, this sounds like a nightmare.
Oh, it's procedural purgatory. You file in federal court, you get sent to state court, you litigate there for a while, then you come back. It splits the case in two, it costs a fortune, and can take years.
So has the system found a way to make this less painful? Because wait and see sounds a lot like pay and delay.
Fortunately, yes. This brings us to a modern tool called certification.
Okay, break that down for us.
Most states now have a process where a federal court can certify a question directly to the state Supreme Court. Instead of sending the parties off to file a whole new lawsuit, the federal judge just writes up the legal question like, does the Texas Railroad Act authorize this, and sends it straight to the top.
So it's a shortcut.
A massive shortcut. The state Supreme Court answers, sends the answer back, and the federal judge applies it. You get the definitive state law ruling without the years of delay. It really saved the Pullman Doctrine from just being a tool for delay.
That seems like a much better system. All right, so that's Pullman. Now let's move to our second flavor, Burford abstention.
Right. If Pullman is wait and see, Burford is more like stay out of the weeds.
And we're back in Texas for this one, right? Burford v. Sun Oil Kell in 1943. But this time, it's the oil fields.
Context is everything here. In the 30s and 40s, the East Texas oil fields were just chaos. Everyone was drilling everywhere, sucking oil out as fast as possible. It was damaging the reservoirs.
So Texas created a really complex regulatory system to manage it all. Spacing rules, proration orders, basically deciding exactly where you could drill and how much.
And to manage this, they consolidated all the legal challenges into one specific state court. They wanted a specialized court that understood the geology, the economics, to handle these disputes so the policy would be consistent.
Enter Sun Oil Company. They didn't like a permit given to Burford. They sue in federal court. And they want the federal judge to just look at this one permit and say it was wrong.
And the Supreme Court said no. They said, look, Texas has created this complex, coherent administrative scheme to manage a vital resource. If federal judges start picking apart individual permits, they're going to throw the entire system into chaos.
It's like a federal judge trying to reroute a single bus line without looking at the whole city's transit map.
Perfect analogy. You pull one string and the whole knot tightens. So the rule of Burford is federal courts should abstain, and in this case actually dismiss the case, when it involves difficult state law questions about an important public policy, and federal intervention would disrupt a coherent state regulatory scheme.
Okay, so how is this different from Pullman? They sound a little similar.
That's a great question. Pullman is about ambiguity. We don't know what the law means. Burford is about complexity and policy. The law might be perfectly clear, but the subject matter itself, like oil regulation or insurance insolvency, is best left to the state to manage as a single, coherent system.
You mentioned insurance. That brings up a more recent case, Quackenbush, right? Because for a while it seemed like Burford was a get-out-of-jail-free card for any complex state case.
Exactly. Quackenbush put the brakes on Burford. The court clarified that you can only dismiss a case under Burford if the plaintiff is asking for equitable relief, like an injunction.
So if I'm just suing for money?
If you're suing for money damages, the federal court generally cannot dismiss the case. They might stay it, pause it, but they can't throw it out entirely. The court really emphasized that Burford is narrow. It has to threaten that coherent state policy.
Okay, so we have Pullman for wait and see and Burford for stay out of the weeds. Now we get to the third one, which feels like the odd cousin at the family reunion. Colorado River abstention.
Colorado River is definitely the outlier. The other two are rooted in federalism and constitutional avoidance. This one is based on something much more pragmatic, wise judicial administration.
Or, as I like to call it, the why are we doing this twice doctrine.
That's a perfect way to put it. This comes from Colorado River Water Conservation District v. United States in 1976. The facts involved water rights. The U.S. government sued in federal court, but there was already a massive, comprehensive lawsuit happening in state court trying to allocate water for the entire river system.
This is what we call parallel litigation. Same parties, Same issues, two different courts at the same time.
Right. And normally that's perfectly allowed. We have a dual court system. You can race to judgment. Whichever court finishes first, that judgment binds the other. Happens all the time.
But here, the Supreme Court said this is just wasteful.
They did, but they were very, very careful. They said abstention here is only for exceptional circumstances. The default rule is still that the federal court has to hear the case. But they created a balancing test to see if the federal court should back down.
Okay, so let's run through that test. What are the factors?
First, is this an in rem case? Is the court fighting over a specific piece of property? If the state court already has control of the property, the federal court should back off.
Makes sense. What else?
The inconvenience of the federal forum. Then there's the big one, avoiding piecemeal litigation.
Right.
This was huge in the water rights context. It makes no sense to decide one person's rights in federal court when the state court is trying to balance the whole river. You want one court handling the whole pie.
And finally, the order of jurisdiction. Who got there first?
But not just who filed first. It's about how far the case has progressed. If the state case is ready for trial and the federal case was just filed, that weighs in favor of abstaining.
So Colorado River is really about efficiency.
It is, but we have to mention a later case, Moses H. Cone. The court made it crystal clear that the balance is heavily weighted against abstention. The presence of a federal law issue, for example, weighs heavily in favor of keeping the case in federal court.
So the default is always federal courts do their job. This is the break glass in case of extreme waste option.
Exactly. It is the narrowest of the three.
Okay, so we've surveyed the landscape. Pullman, Burford, and Colorado River. Now it's time for us to slide over to the 10th chair.
This is where we step back from the doctrine as it is and ask whether it all makes sense.
And sitting as the 10th chair, my immediate reaction to Pullman is frustration.
Yeah.
I get the intellectual purity of not deciding a constitutional issue if you don't have to, but the practical cost to the person suing is just immense.
It's a totally valid critique. Before certification became common, Pullman was almost a denial of justice through delay. You have a right to be in federal court, and the court says, yes, you do, but we're going to make it so expensive and slow you might wish you didn't.
But with certification, I think Pullman becomes much more defensible. It turns a multi-year delay into, a 6-month detour. It allows for that cooperative federalism without bankrupting the litigant.
I agree on Pullman. My concern sitting here is actually with Burford.
Oh, interesting. Why Burford?
Because it's so subjective. The standard is difficult questions of state law involving policy problems of substantial public import. What does that even mean? It feels like it gives a lazy federal judge a release valve to just dump a complicated case.
It creates uncertainty.
Yeah.
I mean, the whole point of diversity jurisdiction is so an out-of-state business can avoid local bias. If the federal judge can just use Burford to kick me back to that local state court because the issue is complex, well, that defeats the entire purpose, doesn't it?
Precisely. Substantial public import is in the eye of the beholder. It risks eroding a statutory right based on a judge's preference for docket management.
Now, what about Colorado River?
I actually find Colorado River the most pragmatic and defensible of the three, as long as it stays narrow. It's the only one that really addresses the pure waste of taxpayer money.
I'm with you on that. As a taxpayer, I don't want to pay for 2 judges and 2 juries and 2 different court systems to decide the exact same fight between the exact same people. That's just waste.
The only danger is if it's used too easily, you encourage a race to file in state court just to block federal jurisdiction. It has to remain, as the court said, truly exceptional.
So ultimately, the tension we started with remains. The unflagging obligation versus the need for comedy and efficiency.
And I think the 10th chair conclusion has to be that abstention is a necessary safety valve, but it must be applied with extreme caution. It should never be used just because a case is hard. It's for when the court's involvement would actively harm that federal-state balance.
Well said. A tool for surgery, not a sledgehammer.
And as a reminder, our analysis in the 10th chair and throughout this deep dive is commentary for informational and discussion purposes only. It is not legal advice.
So to recap, Pullman waits for state law clarity to avoid constitutional questions. Burford respects complex state regulatory systems. And Colorado River avoids the waste of duplicate lawsuits.
And here's a final thought for you to chew on. We often think of power as the ability to act, to strike down a law, to issue an injunction. But in a legal system with 2 sovereigns, state and federal, who really has the final say? Sometimes the greatest exercise of judicial power is having the wisdom to choose not to use it.
A fascinating paradox. Thanks for joining us on this deep dive into the abstention doctrines. We'll see you next time on Talk Trials.